So we're talking about price concerns in a more extended way that people have, and oh boy, um, nothing could be more at the heart of the legal process than considering cost. So obviously you could win everything that you want to, and if the cost is not what it should be, you could spend more money winning your case than it was worth. So if you have an issue that you're fighting over that's $5,000 or $10,000, and you get a legal bill for $20,000, unless you were so committed to winning on principle, that's not a good outcome, and that's not where you want to be. So if we're looking at costs, we give you some rules of the road. The first issue is know thy outcome. That should be a rule of life, know thy outcome, but it certainly should be considering litigation and what it costs you. And when we say know thy outcome, what we're referring to is exactly what I shared. We want to win the case, and we want to make sure we spend an amount of money that makes it cost effective to have done so. So here's where it gets really interesting. In a case, let's say that you're being sued for $1 million or $5 million. There's not, cost is a consideration for sure, but you're fighting about an extraordinary amount of money. So let's say that is a case where it is certainly worthwhile to invest significantly in defending yourself. So we're going to put that to the side and we'll come back to it. Let's talk more about a lesser dollar case where you're asserting your rights and what really happens. And I call this a game of chicken. And really what's occurring, because game of chicken, this is a legal profession, I want to be really clear for what this is. The law is really, in a lot of ways, a contest. It's a game in certain ways. Not a game where you shouldn't tell the truth, but it is a contest of wills between two people, more akin to maybe a sporting event. And you go, really? Aren't you the guy that talks about truth and justice and honesty and integrity? I sure am. But I'm here to also tell you that the legal system is not set up to solely produce truth, justice, and integrity. And the less money you're fighting over, the far more complicated the issues of justice and integrity of the system become. Because for the most part, to get to the end, if you're fighting over, let's say, $5,000 or $10,000, to get all the way through a trial, you're not really looking at a situation where it's going to be cost effective to do it. And I'll drop a footnote right there to tell you this is why it's so important when you enter into contracts to make sure there's an attorney fee shifting provision that's appropriately written that would result in the prevailing party in the litigation getting the legal fees. So let me go through that a little bit more slowly. So if you own a business, if you're entering into any type of contract, and you're the honest person, you're going to be honest, you're a liar, never enter into this. I don't want to deal with you, I don't want to know you if you are, but if you are, right, you never want to have an attorney fee shifting provision. The attorney fee shifting provision protects the honest person. And if you're negotiating with somebody and they don't want an attorney fee shifting provision in the contract, run, don't walk. Run, don't walk. Because the simple way this all breaks down is that when it comes time to litigate, financial leverage is everything, especially in a case that's over a less money. It matters certainly in a case that's over a lot of money, but especially in a case that's over a lesser amount of money. So like, for example, in the Arizona jury verdict, a $27 million case, that was an all-in. Right, we're fighting over a company, a business breakup, a $50 million company that was stolen from my client. It was all bets are off, right? Only. But what if that case was over $50,000? If it was over $50,000, cost is a major consideration in what you'd spend. However, so if you have no attorney fee shifting provision, and that guy in Arizona did all the things to my client that he did, we would have been in where do we go? And he was resolutely committed. He would win any game of chicken. He went all the way, into bankruptcy, and we finally got him there. But he went all the way into bankruptcy. He went all the way through trial and was getting crushed along the way. And he was just like, let's keep going. He was an absolute lunatic in that process. And we got him in the end. But if that was over $50,000, he would have won if there was no fee shifting, because my client wasn't a lunatic, and my client wouldn't have wanted to spend a lot more than $50,000 to recover $50,000. But if there was an attorney fee shifting provision, then all of a sudden now there is real leverage. Because if this goes all the way to the end, and even if you're fighting over $50,000 and a legal bill of $75,000, $200,000, $1 million is created to fight over that number, and it was justified, you're going to get that awarded to you, and that's going to essentially be a punitive leverage type measure against the other side for having created the problem that you contracted for up front. So you always want to have the attorney fee shifting provision. That's the footnote. Always know the outcome. And the next question becomes like, what should you be spending money on in the case? And I could talk about this topic probably for 2 hours, and we will do much longer videos. So we have a really, really short video, and this is a about a 10 or 15 minute. We could do a 2 to 5 hour segment on this, which we'll do down the road, in making very analytical, cost-conscious decisions. So when it comes up, you have a second opinion online. We want to be that resource for you when you're talking to your attorney. There's no possibility of going into each of these different permutations right now, but I want to give you a sense of them, right? So one terribly important consideration is the videotape deposition. If you're going to be dealing with people who are going to be lying, and very often you will, you want to take a videotape deposition, period. You want to take a videotape deposition because when people are lying on camera, it is amazingly obvious. And you could assess right now whether or not you think I'm telling the truth. And I think you're going to think I'm telling the truth because I'm congruent. What congruent means is my words, my tone, my body language are in alignment. Normal people recognize when there's deviations in word, tone, and body language. So if you have a videotape deposition in your case, it's going to show. And the jury is going to be able to tell that person's lying. They're not going to be able to believe them, especially if you have an attorney who's talented enough to push people who are lying and to make those body language, tonal, and physiological changes become more apparent. And we will, again, I know I'm talking about lots of other videos we're doing. You will see deposition videos where we talk about the power of videotape deposition. You will see how incredibly pronounced this is in real footage that we have from some of the cases we did. That, by the way, ended up with an expert witness withdrawing her opinion in the middle of a multi-million-dollar case. And then when it came time to be examined at trial, this witness went on vacation and didn't even appear and left the party with no witness to call because they looked so utterly ridiculous. A paid expert who was such a liar. You'll see other liars in deposition and get the true power of the videotape deposition. So if your lawyer's talking to you about doing a videotape deposition, like, oh my God, it's going to cost an extra $1,000, I need a videographer, do we really need this? The answer is yes, if the people are going to lie or even potentially lie. If you're looking at a divorce case, unquestionably, you should have a videotape deposition, without a doubt, if the party's going to lie. If it's an expert, you always want to have the expert on videotape. The written transcript does not give you a fraction of the power to deal with the expert that you otherwise would. Next question might be, hey, what do we do with an expert? It seems like it's a lot of money. The power of the right expert in your case cannot possibly be overstated as well. Now, you have to always remember rule number one, which is know thy outcome. So if you're fighting over $10,000 and the expert needs $10,000 and there's no fee shifting provision, well, obviously you're not going to retain an expert. But if you're fighting about more than that in a significant way, and we can get through those permutations in the longer videos that we'll do, you without a doubt want to have a great expert. But all experts, just like all lawyers, just like all doctors, like all accountants, are not created equally. So the job that your lawyer does in selecting an expert with integrity, with a strong background, is imperative. And where I see a lot of lawyers making a huge mistake, and I saw in multiple cases that we've handled, especially the large jury verdict cases that we talked about in some of the other videos, the 2 top 100 national verdicts. The issue, the other side had guys, women, that had no credentials. They weren't effective. They were lying, and they weren't able to see that because they didn't spend the time to look for it. It would have been readily apparent. When I saw the curriculum vitae, that's the resume of one of the experts, I couldn't believe it. It was utterly ridiculous, and clearly somebody we're going to be able to destroy. And then when it comes to the report writing, a lot of experts are very poor report writers. They may have valid opinions, but if their opinions aren't reviewed in the context of the trial ready, then there's very significant problems. So what is this all amounting to? This is amounting to a discussion of, you have to know thy outcome, because how much money you spend on your litigation can vary amazingly. You could spend $2,000 litigating a case, possible, and you could spend millions, and anything in between. And that may have a relationship to the quality of legal counsel that you have, but it also is going to have a lot to do with how much work is done. Are you going to request an entire database dump of 100,000 documents? Well, you're not going to if it's a $10,000 case. You are going to if it's a $20 million case. And making each of these financial decisions, you need to feel the certainty and confidence from your attorney that they know why, they know the outcome, they can explain how it fits into the context, and that it's the right investment in the situation. So, in a nutshell, if you ever have any questions, you have another case, and you deal with an attorney, you want a second opinion about what you should be investing and spending your case, give us a call, shoot us an email. And if you want us to represent you and you want us to really talk about, have a law firm that's really going to talk to you about cost, help you understand cost and investment into your case, talk to us. I'm Sean Callagy. This is Callagy Law. I wish you all the best.